Good evening again, and welcome to another episode of Maintenance Matters. Today we have Advocate Deon Ruiters with us. He is a Senior Maintenance Prosecutor in Cape Town. Deon, welcome.
Hi, Eugene. Welcome.
How are you today?
I'm very well, thank you.
Fantastic. Now, Deon, on our Facebook groups, we have a lot of complaints about complainants that hand in their maintenance application at court. Once they completed that, they just hand it in court, but they don't know the process afterwards. What happens to the process afterwards up until the stage that they go to court? Because there's a common misperception of the people out there that once you give in the forms, the matter will be attended to immediately, and that does not necessarily happen in the maintenance courts. So can you briefly explain what is the process after you filled in the maintenance application form, the so-called J101 form, which they are quite familiar with? What happens after that?
Okay, the process afterwards is being governed by the DOJ maintenance code. They call it the DOJ Family Code 26 of 2015 on maintenance matters. So the clerk is supposed to assist the maintenance applicant whenever she comes to complete the J101 or the J107. And once those forms are completed, and she's obviously been assisted by the maintenance clerk in completion of the form, calculating the expenses of the child, the Section 15 pro rata contribution of each of the parents.
Then, okay, well, can I just stop you there? You're talking about very technical detail. Let's just backtrack a little bit and say, okay, right. Let's start off with, you say they need to complete the expenditure and the list. So that is the form that they use.
Yes. That is the J101 form, where they will put in what is the expenses of the child, what is the expenses of the mother and the rest of the family, whoever's living there. And those shared expenses like water, electricity, food, all of those expenses will be indicated on the J101. Now, a lot of applicants find it difficult or don't know how to calculate those expenses. Now, the DOJ Code 26 of 2015 says that the clerk sitting in the maintenance office or the maintenance officer is over there to assist them in completion of those J101 and J107 forms. So the policy document of the Department of Justice is clear on it. They need the assistance.
That is a document that you refer to, the DOJ form, the DOJ Code 26. That is their policy form. That is their set of rules that they need to follow and to abide by in maintenance matters.
That's yes.
No, it's fine.
And the DOJ Code 26 of 2015 is so clear that if the DOJ clerk or the DOJ maintenance officer do not comply with their own policy document, then there is disciplinary step that can be followed in a case where there's non-compliance with the DOJ code. So if the code on page 13 says it must be black ink and it's not black ink, then the specific individual that completed it in blue ink or whatever ink can actually be held accountable for it. The same in the case of the calculations of the expenses of the child or the contributions or the income that will eventually, in terms of Section 15, determine the pro rata contribution that every parent should make. If those are not complied with, or where the clerk is not assisting the specific applicant, then there is supposed to be disciplinary measures that can be imposed on that specific clerk or maintenance officer in not assisting the individual with the J101 or J107.
You mentioned something about this Section 15. Now, a lot of people might not be familiar with Section 15 on how the contribution needs to be allocated. And most of the people out there think that it is a 50-50 split between the mother and the father. And that is a common misperception. And we are trying through our webinars and education and training sessions to tell the people that is not correct. Could you just a little bit explain more your view on that?
Sure. So what the maintenance legislation in Section 15 says, it says that those contributions should be according to your income or according to your means. So if we find that the respondent is alleging to be unemployed but is having retirement annuities, or he's got a lot of taxis, or he's got a lot of other assets, then those assets should also be taken in consideration as part of his means. So means is not just your income that you're earning at the place of work, but it can also include any other assets that you have. So your pro rata contribution will not just be the fact that you're earning a salary, because most respondents might come to court and say, no, but I'm unemployed. But they will not declare that they actually are having a business on the side, or they are having a retirement annuity, or they have any other type of investments that they will not make clear. So it's important for the applicants to know that she should divulge that information to the maintenance clerk or the maintenance officer, that actually this person is trading on Forex and is earning a lot of income on Facebook. He made it known that he's such a good Forex trader. All of those things, the maintenance clerk or maintenance officer will not know that unless our source of information, which is the applicant, divulge that information to us. So means is not just the mere fact of an income. It can also be any other assets, or any other type of investments, or any other type of forex trading, or any other type of ways that you somehow can accrue an income. Those are what you are supposed to be your means. And all of that needs to be taken in consideration in terms of Section 15 to be able to get to what we call a fair, equitable distribution of what the shares expenses of the parties should be. Section 16 of the Maintenance Act says that that decision that is ultimately made by the maintenance officer and by the court must be fair and equitable. And a 50-50 share will never or can't be fair and equitable if the lady was sitting at home and now all of a sudden, because the relationship went sour, now have to go and look for an employment, and she finds an employment where she is earning 30 or 40% less than what the respondent is earning, and the respondent then insists on having a 50-50 split. And I've seen a lot of these cases in court where women, especially our mothers, are under the misconception that they should, in this specific case, contribute 50-50 to it. That's not true. The legislation is clear. It must be fair and equitable. It can't be equitable in a case where the lady is earning 1,000 and the husband is earning, or the ex-husband is earning 10,000, that the share should still be 50-50. It cannot work like that. So once our public is informed that it is never 50-50 and it's according to your means, then the hopefully the maintenance clerk or the maintenance officer and the maintenance magistrate that might ultimately deal with it will be aware that it can't be 50-50 and will do the distribution.
Fantastic. Another thing, you keep on mentioning the DOJ Code 26. Is that code available? Is it a public document that the people out there could access? Could they have a read through it?
The code is not in the public arena, but it is available in the DOJ code. It says that there must be a copy at court in their offices, and there must be a copy in the library. So the members of the public, whenever they are approaching the maintenance court, can ask the clerk or ask the maintenance office, can I see your policy document, and can I read your policy document? But it's not a document that have been published on the internet or on any of those places, but it is available at the library, at every court. According to the code, it says there must be a copy in the court library, as well as these documents must be readily available to all new appointees. So all of them should have a copy in their office. If they don't have a copy in their office, it should at least be available in the court library. And members of the public will be able to ask to have access to it, to read through it. It cannot be a document that is just being kept in a library for it to gather dust, or for a new person to come and view whenever they want to. It should be available to everyone. I feel all policy documents should be available. That's the only way we can keep people accountable.
Yes, that's actually very true. Speaking about being accountable, we see on our different groups, Facebook groups, we see that most of the complaints are regarding the time that it takes from that they hand in the application form up until they actually or something happens. We had some people saying that they wait up to 9 months to just be helped at the courts because the matter is forever being postponed. Because it could either be that the maintenance investigator was not available or maintenance officer was not available. What can be done in such circumstances?
Well, first of all, the Maintenance Act is clear on it that whenever these cases are being heard, the best interest of the child should be the ultimate goal in serving the applicant as well as a child. Section 10(6) of the Maintenance Act says that the maintenance court should limit the number of postponements and duration of these maintenance matters. There is nothing that stops a maintenance clerk from picking up the telephone while the applicant is in her office or in his office and submitting that specific maintenance form. The Act is clear that it should be limited in duration as well as in the number of postponements. So what I would usually recommend to the maintenance staff is while the applicant is standing there and there's a cell number, call the respondent and find out when will he be able to come into the courts. And I've dealt with cases in the Western Cape area where the respondent will be called at the morning 10 o'clock, and by 2 o'clock the specific respondent will be in the maintenance office. There's nothing that stops any specific maintenance clerk from picking up the phone and calling the respondent and getting him to come to the court the same day or the next day. In some areas, I've dealt with cases where we would just ask the respondent to come in the next day and then deal with the case and be able to conclude at least a consent order where he consent to contribute a specific amount. And in cases where they can't contribute the specific amount, there's nothing that stops them from then at least making an offer of a lesser amount than what is required that can then, in terms of Section 10(6), be made an interim order. So where there is going to be a postponement after the first time that both parties, both parents, the mother and the father, sitting in front of the maintenance officer, then there's nothing that from that moment stops that specific court from making an interim order. If the respondent do not have his bank statements or salary or whatever he needs to still bring, then the maintenance officer have a duty in terms of Section 10(6) to at least conclude a interim order while pending the submission of the other documents that is necessary. So I always encourage the maintenance staff to always get an interim order after the first session when both parties are at court. There's nothing that stops them from it. And the Maintenance Act in Section 10(6), as well as the Constitutional Court in Judge Yvonne Mokoro's case, Bannatyne versus Bannatyne, said that these type of matters we need to deal with urgency and get those type of orders as soon as possible. Even if it's an interim order, then at least have an interim order in terms of Section 10(6) after the first appearance. It cannot be that people will have to wait 6 months or 9 months down the line before they at least conclude some type of monetary amount that is made an order of court. As soon as there is any problems in between, the words that needs to be in any maintenance officer's mouth is interim maintenance order. That should be done the same way in divorce matters. You will, in the High Court, get a Rule 43 orders, which is a financial interim order, or in the regional courts where the divorce orders are also being made, then a Rule 58 interim financial order can be made. Similar in the maintenance court, in terms of Section 10(6), an interim maintenance order can also be made like the way it's being done in the divorce courts.
The last question that I have is also a question that pops up quite frequently on our Facebook groups. the complainant is given certain documents to serve herself or with a request from the courts that they need to take it to the police station, and the police must accompany them to serve documents on the respondent or the father. What documents are they talking about, and what is the procedure and the rules and regulations pertaining to service of documents specifically in maintenance matters?
Okay, I will first deal with the first document that is issued after the application is then submitted to the court. The first document that will somehow invite the respondent to court is called a regulatory directive. Now, a regulatory directive is a document that is like a subpoena submitted to the police or to a sheriff of the court or a maintenance investigator to serve that document on the respondent in order to invite him to come to court. I'm saying invite him to come to court because it is actually just like an invitation. It's not so serious like in other summons process that we are used to, where you either come that day or else there will be consequences. But there is consequences even in the case of regulatory directives. Where in a
What
case
are
where
the
it doesn't
consequences on that? What might be the consequences if they do not appear on the invitation or the directive?
In terms of regulatory, it says that it's a criminal offense in a case where they do not come to court and they knew about it. The most important thing is they must have received notice and they didn't comply with the notice by being at court. Then the regulation says it's a criminal offense and they can be charged. A warrant of arrest will be issued. Once the warrant of arrest is issued, then the police will go and arrest the respondent that didn't come to court on the regulatory directive, and then he can be sentenced in terms of the regulatory, even to a custodial sentence, and be sent to prison for not complying with it. That's how serious it is. In a case where he do not listen to the regulatory directive, the only problem is a default order cannot be issued on a regulatory directive because the Act in Section 18 says you can only issue a default order in a case where there is a Section 9(2) summons that was issued. So, unfortunately, in a case where it doesn't come to court, the applicant cannot request that a default order be made by the court because Section 18 of the Maintenance Act is clear. It can only be issued in the case of a Section 9(2) summons being issued.
Okay, so explain to me, what is a Section 9(2) summons?
Okay, a Section 9(2) summons is similar to a summons that will be issued by a court. Now, Section 9(2) summons is when the specific individual attended court, or both individuals attended court, and there isn't an agreement as far as the actual amount that should be paid for maintenance. Then the maintenance officer will then request that what we call a Section 10 inquiry be held in front of a magistrate. Now, the first process happens in the maintenance officer's office. It happens where the two parties, the mother and the father, will be sitting in front of a maintenance officer. Now, that is the first part of the inquiry that we call the Section 6 inquiry, where the investigation.
That's the informal inquiry that is done at the maintenance officer's office.
Yes, we call that informal inquiry. From the informal inquiry, if there's no conclusion or no agreement as far as the quantum, the amount that needs to be paid, then it will go to a magistrate that will then hear that evidence and how much the applicant wants and how much the respondent is willing to give, or what is the respondent's salary, what's the applicant's salary, what's the expenses of the child. And based on that, the court, a magistrate will make a finding. And once the magistrate heard all the evidence, the magistrate can make a court order on what we call a Day 168 court order document. And that's when that order will be made, where the respondent didn't agree to the amount, the applicant wasn't happy with the amount, then the court will intervene and the court will make a decision. Now, when it gets to that stage, that document, in order to get the parties to come to court, like the respondent or the applicant, they are both summoned with what we call a Section 9(2) summons. Now, that document is the document that is submitted or that is issued by the Department of Justice's maintenance officer, and then being served by a police officer or by a maintenance investigator to the parties. It can be served to both the respondent and the applicant, especially if an applicant is working and she wants to have something formal to show to her employer, that she can ask that she also be formally summoned. But in most cases, what sometimes happens during that investigative process, the Section 6 informal process, the maintenance officer might just warn the parties and say, listen, our next date is in April, so both of you are warned for that day. But if the applicant insists on getting a summons, then she can ask for Section 9(2) summons that she can submit to work, and that document she can also use in terms of Section 11 if she wants to claim subsistence and travel allowance or a wage that she forfeited. Then she can do it by making sure that she's formally summoned and the employer is aware of it, and the employer submit a document stating that he's aware that she went to court, she lost her wage for the day, therefore this is what she would have lost. In terms of Section 11(1), she can claim that subsistence and travel allowance from the court, including a lost wage.
Okay, that's very good news, and we'll definitely pick up on that on some of our next conversations. Deon, thank you so much for your time and trouble. This was another episode of Maintenance Matters. We will be chatting to you very soon. Thank you so much, and have a good night.
Thank you, Eugene.